Counsel?
Thank you, Your Honor. Tim Rooney.
Remain standing, please. Face the clerk and raise your right hand.
I do.
Please be seated. State and spell your name for the record.
Timothy Rooney, Rooney.
Thank you.
Mr. Rooney, you're employed by the Santa Barbara County District Attorney's Office, correct?
Yes, sir.
How long have you been with the District Attorney's Office?
16 years.
And in what capacity are you employed by the District Attorney's Office?
Senior criminal investigator.
Before that, did you have law enforcement experience?
11 years with Santa Barbara Police Department.
Okay. Now, on November 18th, November 18th, 2003, were you assigned to participate in the execution of a search warrant on Neverland Valley Ranch?
Yes.
And what was part of the assignment that you were given that day to participate in the review of some documents and logs in the security office?
Yes.
And were you working in conjunction with other people in doing that?
Yes, sir.
I'm not sure that mic's working. You might want to try that one there.
Okay.
And who was it that you were working with in processing these documents?
Sergeant Steve Cleaves from the Sheriff's Office, Deputy Moeller from the Sheriff's Office, Tim Sutcliffe from the Sheriff's Office, Shelley Sweeten, a criminal investigator with the District Attorney's Office, and myself.
And from where did you obtain the materials that you personally went through?
From the security area.
And were they in some form of containers?
Yes.
What kind?
Some were retrieved from files that were in file cabinets and boxes.
Now, what is the process that you used in? First of all, were you given a list of names of people to look for on these logs and records?
Yes.
And what was the nature of the records that you were looking through?
Records consisted of logs of people going in and out of the ranch, employees, guests, business vendors.
And you had a list of names to look for, is that correct?
Yes, sir.
And during the course of your examination of the documents that you personally examined, did you have occasion to remove some of those documents?
Yes, I did.
And after you removed them, what did you do with them?
I notified Deputy Moeller and he scribed them, took them from my possession and documented them.
So he took them from you, you gave them to him and he documented them.
Yes.
Is that correct?
Yes, sir.
Now, have you had a chance to review the documents that you took on that particular day?
Yes.
Generally speaking?
Yes, I have.
Do any of those documents include documents after the date of December 31st of 2002?
I don't believe so.
No further questions.
Good morning.
Good morning.
It's still morning. We always have to check here. We get kind of out of sequence. Did you write a report in this case?
No, sir.
Your assignment, among other things, was to look through those documents. Is that correct?
Yes.
Were you assigned to do anything else in this case?
I helped search the video movie room that he had.
The video library?
Yes, the library.
I'm sorry.
The video library at the ranch.
I didn't mean to talk over you. Okay. The video library was upstairs in the same building as the security office?
Yes.
And you also were assigned to stand watch over the guest units until somebody came to search them?
Yes.
Okay. Other than that, did you do anything else in this case?
I went to the back employee area and stood by till somebody from the sheriff's office came and contacted the employees.
Okay. Did you search the administration building? Let me ask the foundational question. Do you know where the administration building was on the ranch?
No, sir.
Okay. You were down at the main residence on the adjoining building with the video library and the security office, correct?
Yes, sir.
You did not go up on the hill to an administration building to search there, did you?
Yes, that's the building I was referring to in the back. I didn't search there, but I stood by with the employees until somebody from the sheriff's office relieved me. I did not search that area.
You're saying, the back. Do you mean right behind the house?
Up high where you're talking about.
What does that building look like?
I don't remember.
Was it an industrial-looking building?
I believe so.
Okay. So we're then talking about is that the building that has a fire truck up there?
There were no fire trucks when I was up there, I don't believe, but other employees' vehicles.
Alright, okay. In any event, you did not search inside of that administration building, is that correct?
That's correct.
And you're aware at the front gate there is an office at the gatehouse, is that correct?
Yes, there is.
Did you search the office at the gatehouse?
No, sir.
Okay, thank you. No further questions.
Nothing further.
Thank you. You may step down.
Detective Moeller, is that one on?
It's on.
Remain standing. Face the clerk. Raise your right hand.
I do.
Please be seated. State and spell your name for the record.
My name's Steven Moeller, Moeller.
Thank you.
Alright, Mr. Moeller, you're going to have to scoot up to that microphone there.
Can you hear me?
That's perfect. That's as good as it gets in here. Alright, you're a deputy employed by the Santa Barbara County Sheriff's Department?
I am.
How long have you been with the department?
30 years.
And what are your current duty assignments?
Currently I'm attached to the Aviation Bureau of the Sheriff's Department.
And on November the 18th of 2003, you are one of the people who participated in the execution of a search warrant at Neverland Valley Ranch. Is that correct?
That's correct.
And on that particular occasion, were you assigned some responsibilities in connection with the execution of that warrant at the security office?
Yes, I was.
And what were those responsibilities?
To go through various documentation looking for specific names on the list, and doing a basic search of that security office.
Alright, and were you assigned a particular responsibility with regard to any of the documents that were found during the course of that search?
Yes, I was a scribe.
What's that mean?
That means that I, for the search team, once they find something that they believe they want to hold as evidence, they turn it over to me, I assign it a number, and then I fill out the property sheet.
And then after you assign it a number and you fill out the property sheet, what do you do with it? What did you do with it on this occasion?
The evidence?
Yes.
Bagged it.
Okay, and then after you bagged it?
I turned it over to the evidence officer.
Alright, now, you were working with some other officers in the security office who you provided the scribe responsibilities for. Now, who were the other officers you were working with in there?
There was Sergeant Steve Cleaves, Detective Sutcliffe, Detective Rooney, and Detective Sweeney.
And as they gave you the particular item and you assigned a number to it, did you make out what's called an SHISH 451 form?
I did.
What is that, for the jury?
Basically that takes the evidence that's turned over, any description of that evidence, and we log who located that evidence and what location.
Alright, I want to show you a series of exhibits, with the court's permission. I can approach the witness, if I might.
Yes.
And counsel, this is 300 through
334.
334. Excellent. I'm going to ask you to examine the items 300 through 334, which basically ends where that yellow tag is.
Your Honor, I'm going to object to this procedure as cumulative, in that there's already a foundation and these documents were admitted.
I have other questions about the documents that I'm going to ask.
I'm not going to rule on your objection, because I don't know. He's just asked him to look at the records. So I don't know if it's cumulative or not.
Okay, have you looked at all those documents?
I have.
Now, with regard to the very last one, this is People's 333, it's in evidence, it's the one, yeah. Flip that over, because I'm going to ask you a question about. No. Flip it this way.
Okay.
With regard to that particular document, in the upper left-hand corner is a number written in ink, is that correct?
That's correct.
And do you recognize that number?
Yes.
Okay, did you put that number on there?
I did.
Okay, now, go back one more document, if you would. That document, excuse me. With regard to the exhibit we were just talking about is in small numbers, black ink, correct?
That is correct.
Now, go back one more.
May I approach, Your Honor? I'm not sure I'm following this.
Yes.
It's the same as in yours.
It's a different colored ink on that one. This is not colored.
It's black.
I see. Okay. That was the first number? Can I just ask where the second number was?
602?
That's on 601.
601.
In the upper left-hand corner of the document.
Alright, thank you.
Moving back, the next document has, in the upper left-hand corner, what number in black?
635.
Is that your handwriting?
Yes.
Now, the handwriting with regard to 635 compared to 601 is significantly larger, is it not?
It is.
Okay. And with regard to the review of the documents that I asked you to do in front of the jury here, those all have large print on them like the 6. Like the one that's marked as People's 332, correct?
Correct.
So even though they're smaller in size in one case and bigger in others, it's the same handwriting, your scribe?
It is.
Do you have your Shish 451 form?
I do.
With you? Don't look at it yet. I'm going to ask you a question.
Okay.
And if you have to look at it, I'll let you do that.
Oh, okay.
With regard to the items that were given you from number 300 through 332, okay?
Okay.
Were any of those documents beyond the date of January 1, 2003?
I don't believe so.
Would your Shish 451 help you refresh your recollection to that effect?
It might.
Make sure you're certain of that. Let me just ask you a question. Your report, your Shish 451, is listed by item number, correct?
Correct.
So it doesn't necessarily correspond, without individually looking at every page, as to which is which.
Correct.
So why don't we just turn all the way back, just momentarily to get the place on this, to item number 300, or item 301. How's that? Just turn the book to 301.
301.
Okay. And that corresponds to your item number 614, correct?
Correct.
Just run consecutively to 614 down to the end of your documents.
I'm going to object, Your Honor.
Let me do it another way.
Sorry. Go ahead.
Just please review your form for right now.
Okay.
And, now, does that refresh your recollection as to whether or not items, the evidentiary items 301 through 332 were all items from the year of 2002?
With the exception of one.
I'm going to object, Your Honor. The exhibits speak for themselves. We're getting a report about the exhibits.
He just asked him to refresh his recollection. If I understand your objection correctly, I'll overrule it.
Well, the objection was. The question was, what is the dates on the exhibits, not in his report.
He asked him to review the item and see if it refreshed his recollection.
This would be only through items. Your item 635?
Correct. 2002.
I think what's happened is the question is in two stages. So I'll ask you to break the question down to two separate questions.
Yes, Your Honor. I will do that. Does reviewing your Shish 451 form refresh your recollection as to whether or not the exhibits 301 through 332 are all from the same year?
Correct.
And that year would be what?
2002.
And there was a single document which is Exhibit 333, correct?
Correct.
One-page document. That was from the year 2003?
Correct.
Nothing further.
The only problem is the book that was given to me has a 2-page document. Maybe it's 2 sides of 1 page. May I just inquire? 333, is that 2 pages, or is it 1 page with 2 sides, or what is it?
2 sides.
Actually.
Well.
1 piece of paper?
No, 2 pieces of paper.
So basically, then, the answer would be Exhibit 333 is 2 pages that pertain to 2003?
Correct.
Without getting too complicated here, you have a number of records which include gate logs from 2002.
Correct.
And then you have 2 pages, which is Exhibit 333, that are not gate logs. Is that correct?
No, they're not.
Okay, so you have, those are a Neverland Valley Fire Department emergency medical report from 2003, correct?
Correct.
And then there's a Neverland Valley medical report log from 2003?
That's also correct.
So those medical reports are from 2003. The gate logs that you scribed in during the search were from 2002?
Correct.
There you go. Now, by the way, is your assignment with the Aviation Bureau, does that mean you're up in the air full time in a helicopter or a plane?
Yes.
That's where you are at all times?
As much as.
As much as you can, probably?
As much as the county can afford.
When did you first get that assignment?
Approximately 6 years ago.
Alright, so at the time you were assigned to do this. You were taken out of the air to come down to the ground and help out?
Actually, during that year that the search warrant occurred, I was temporarily with the narcotics unit for about 8 months.
So you were working as a detective?
I was.
And you have prior experience as a detective in the department?
No.
That was your only time as a detective?
Yes.
Alright, now, you were briefed on this search before you went out to the ranch, correct?
Correct.
And you received a copy of the search warrant, correct?
Correct.
And you were aware of the structures that were covered by the search warrant, is that correct?
Correct.
And that would be the main house, correct?
Correct.
The security office, correct?
Correct.
And then the arcade building?
Yes.
Did you search the administration building?
I did not.
Do you know where that administration building was?
No.
Were you aware there was an industrial-looking building up on the hill?
If that's by the fire department.
Yes.
Area, yes.
You're aware of that building?
I'm aware of that building, yes.
But you did not search it?
I did not.
And you're aware of the gatehouse or the office next to the gate, the very front gate on Figueroa Mountain Road, correct?
Yes.
And that was an office that was not searched as well, is that correct?
I did not search that.
Alright, okay. No further questions.
Nothing further, Your Honor.
You may step down.
Your Honor, we'll call Jeff Klapakis as our next witness.
All right, come forward. When you get to the witness stand, you may be seated. You're still under oath.
Yes, sir.
Good afternoon, Lieutenant Klapakis.
Good afternoon.
You've previously testified in this case that you were a lieutenant assigned to the Michael Jackson case. During the month of January in 2004, did you serve a search warrant on the home of F. Mark Schaffel?
Yes.
And where did you serve that warrant?
In Calabasas, California, at his residence.
What was the date of that the warrant was served?
January 31st, .04.
Before we go any further, yes, alright. Before we go any further, could we approach the bench briefly?
Yes.
Thank you. Discussion held off the record at sidebar.
To the jury, before we have any further testimony, I have to hear some motions, and not just as to this witness, but to several witnesses that the district attorney is anticipating calling. And I don't see any way that we could complete those this afternoon, so I'm going to have to let you go home.
In unison, oh, laughter.
I knew you would be disappointed. So you don't come back.
In unison, oh.
And I'll see you Monday at 8:30. Remember the admonitions. Let me just say one thing to you. This is not unusual. When you get to the end of either side of the case, it starts stuttering. Every case I've ever had, the witnesses that are left are the ones that have something that I have to do, and it's just not unusual. I don't want you to think it is. It just cases don't just ride out to the end smoothly and stop. At least not in my court. They always go bump, bump, bump. That's where we are. Bump, bump, bump. So I'll see you next Monday. I'm going to just leave the stand for a moment until you're ready to start the motions.
Your Honor, before you start on the motion, I asked Mr. Dunkel to come over and sit in, because so many of these things were filed at the last minute and he's worked on responses, so I'd like to have him here. And he'll be here in a few minutes, but we can start without him, of course.
That's fine. All right. The first item on the calendar is the plaintiff's motion in limine readmission of expert testimony on battered women syndrome. I deferred ruling. I would like to have Mr. Sneddon, whoever is handling the motion here, explain to me why this witness is necessary, what you intend to prove.
This is my motion, Your Honor. And given the enormity of the evidence concerning Janet Arvizo's 16-year abusive relationship at the hands of her husband, and given the fact that the charges and facts of this case fall immediately upon the end of that 16-year relationship, both sides have made the issue of this relationship central to this case. The defense has even attempted to use this relationship to show that Miss Arvizo was somehow fraudulent in the J.C. Penney case by attempting, I won't concede that they were successful, but they attempted to lead the jury to believe that some of her injuries were, in fact, caused by her husband. So there doesn't seem to be any contention that both sides agree that this woman suffered at the hands of her husband.
I guess the issue that I want discussed is what is the relevance here. The code section says that if you show relevance and you have an expert that will so testify.
Very well. I'll go straight to the point. False imprisonment, child endangerment, personal verbal attacks, death threats, isolation, hopelessness, emotional abuse. These are all the central issues of domestic violence. They are also the central issues in this case. Domestic violence evidence, expert evidence by a battered women's syndrome expert, is designed to debunk misperceptions about women who have suffered this post-traumatic stress disorder. Women who have been raped, women who have been beaten, women who have been abused do not act in a predictive manner. There are many misconceptions about how Janet Arvizo should act, given the stimulus of the defendant's conduct in this particular case. Specifically, these are problem areas for this jury that this expert will help them now to wade through. Specifically, why did she return to her abusers at Neverland? The jury needs to understand that victims of domestic violence virtually always return to their abusers. Why didn't she go to the police? Why doesn't she report this? Victims of domestic violence, this expert will testify. Victims of domestic violence, when they're threatened, when they're abused, when they're taken advantage of, they virtually never go to the police. Why didn't she make greater attempts to leave? Why didn't she just walk away? Those are the questions of people who wonder why these women stay in these domestic violence relationships. This expert will help this jury understand this issue. Why she's still susceptible, why she's so gullible. Common traits in domestic violence cases. Why was she so easily manipulated? Domestic violence victims are routinely manipulated by the men who abuse them. Why did she continue to trust in people who had proven they were untrustworthy? Another common trait, this learned hopelessness. That's the terminology that the experts use, learned hopelessness, that they become eternal believers in. Well, you know, if I just toe the line, if I just do what I'm told, if I don't make any waves, if I don't make any fuss, everything will be okay. Why did she act so helpless? A common question that we all have of victims of domestic violence and a common trait that's certainly associated with this disorder. Why did she continue to have hope and faith in Jackson when Jackson's people were conducting this conspiracy around her? Again, this sense of hope, trying to find some light at the end of the tunnel, trying to believe, wanting to believe. She wanted to believe that Jackson could help her, even when all the evidence was contrary. Why does she lie under oath? Now, here's an important point. The defense has placed that fact in the center of their attack on Janet Arvizo. They've charged her with perjury. They made a big deal about it. They questioned her extensively about that. And this expert will come forward and tell you that victims of domestic violence virtually always or routinely lie under oath and protect their abusers. And that's exactly what she did in this case.
But I'm having trouble keeping up with you here. Are you talking at this point about her lying under oath in depositions about whether her ex-husband was abusive or not?
Yes, I am.
But just before that, you were attributing you were sort of placing Mr. Jackson in the position of a husband, weren't you?
Well, I am. I'm placing.
You made a big jump there.
Well, I did. And I'm saying that Mr. Jackson was in a position where he could exploit the vulnerabilities of a woman who suffers from post-traumatic stress disorder. Now, the statute itself says that the common misperceptions regarding battered women's syndrome is admissible to help the jury understand the nature and effect of the physical, emotional, mental abuse on the beliefs, perceptions and behavior of victims of domestic violence. Janet Arvizo's beliefs, her perceptions and her behavior in this case have been called into question by the defense. And those beliefs, perceptions and behaviors were altered, permanently probably, during those 16 years of being a battered wife. Now, there are some interesting parallels here, even though Mr. Jackson is not in a position of being a typical classic father figure in a family. I mean, there's the family overtones. There's the I'm going to take care of you overtones. There's certainly some interesting parallels here. But this is primarily to help the jury understand why Janet behaves the way she does. Many questions are asked about this, and questions that have been focused on by the defense. And Janet behaves the way she does because of her history as a victim of domestic violence. Because of the stimulus that's provided, death threats, she reacts that way when she gets death threats. When she's scared, when she's upset, she doesn't go to the police. When she's feeling hopeless, she locks herself in a room and sits there on Neverland and doesn't go out and see anybody. Is she paranoid? Yes, as most victims of domestic violence are.
The thing I'm having trouble with is that the case where this usually arises is in a case where, if it's a husband, let's use that as an example. A husband is charged in court with abusing his wife, and she testifies, and there's a lot of inconsistencies because she didn't report it, or at other times she said he was abusive, he wasn't abusive, that type of thing, and you have,
well,
the testimony to explain her. It's not too different from the child abuse accommodation syndrome, where the child doesn't accurately report and you bring in an expert to suggest why that would be, in the total scheme of things.
And you're exactly right.
In this case, that's not the situation at all. I mean,
This is an unusual hybrid. I couldn't agree more. But as you pointed out, there's two tracks here for admissibility. One deals with the conduct of the defendant, and trying to understand Janet's conduct, which I think is just something that this jury absolutely has to have to help them understand Janet. She suffers from a post-traumatic stress disorder. They should be apprised of that and the classic symptomology, which is completely counterintuitive. And we don't want this jury to make this decision based on misconceptions. And there are an abundance of misconceptions of how women should behave and how they actually do behave when they've been abused by domestic partners. But the other side, the other track, which is completely independent of this and which this evidence should come straight in on, is to explain why she didn't tell the truth under oath. It goes straight to that issue, which the defense has chosen to make a centerpiece on their attack on Janet. So for the jury to understand why did she perjure herself, why did she lie about her husband, that's a highway to bring this type of evidence in so that the jury can understand, that's normal. Women who are abused do that. It shouldn't be held against her, and it shouldn't be used against her the way this defense intends to do, and the way they tried to do when they examined her, and the way they ultimately will do when they argue this case. So on one hand, the defense has asked for it. They've asked, they should have all the evidence on what the reasons why she perjured herself. But on the other hand, there are many enigmas about why Janet acted the way she did, and those enigmas are largely explained when people understand that she's exhibiting the classic symptoms of post-traumatic stress disorder. And I might point out finally, just that under the code, under the section here, this is not exclusively used in the case of battered women's syndrome where there's a domestic violence, where the husband is charged and the woman is the victim. I mean, the code itself says, whenever it's relevant. So it's not a matter of whether it's normal or not. The question is it relevant? Does it have a tendency and reason to prove?
Well, it's just that the relevancy is very clear under the typical scenario.
Yes.
It's not so clear here.
But even in the cases don't always just go to that classic scenario. Sometimes it's used on the other side of the coin. Sometimes it's used to show why the woman assaulted the man.
Well.
And there's case law on that as well.
Yeah, and
so
I chose the example of the man assaulting the woman because that's the scenario we have in front of me.
Sometimes it's used to show that the defendant, it's not only used to show the victim suffered from post-traumatic. Sometimes it's used to show the defendant suffered.
Oh, I see what you're saying.
When the woman is charged with murder, for instance, and an expert is introduced to show she suffered from battered women's syndrome. So there are other cases. But I agree with you, it's not always simple, but we are not always confronted with simple facts for the application of the law. But I will say that it is abundantly clear that, under the defense's own intent and their own tactic in this case, they made it relevant, at a minimum, by charging her with perjury and parading that out in front of this jury. so I would submit there are two very strong reasons that make this evidence highly relevant. And I don't think you can dispute the fact that much of her conduct is counterintuitive, and that it does fit within a pattern that is prevalent among women who are victims of this.
But you're saying that the expert's going to testify that not only does the spousal abuse accommodation theory explain why a person doesn't report, prosecute, etc. a person who is physically abusing them, and will say that that's equivalent to this case where.
Yes, she will say that. She will say that this disorder, the symptomology of this disorder, is not isolated to the home. When they walk out of the home, they carry this disorder with them. When they are confronted in the world with the similar stimulus that they have in the home, such as death threats, such as false imprisonment, such as threats of child abduction, such as trying to obtain control, any act of power, isolation and control, which we have here, when they're confronting these types of influences, they react the same way they do in the home. The post-traumatic stress disorder goes with them wherever they go. And that's what this expert witness will testify to. She will testify to that these types of incidences are Janet suffering from this syndrome. That this type of behavior is, and not specifically, but generally, because this will be general testimony, as it should be. It's to demystify the area. But she'll testify that women do not leave this disorder when they walk out of the house or even when they leave their husband. So.
Okay, Mr. Sanger, are you going to discuss this?
Yes, sir. Yes, sir. We briefed it, and I think the court has hit one of the major points on the head, is that this isn't relevant to this kind of a case. But responding to what Mr. Auchincloss said in an effort to answer the court's question, we didn't make her perjury relevant. She has committed perjury, I think it's pretty clear, in this court from the stand. And she has said things that are preposterous, that are absolutely counter to the other evidence in the case. And that's not because she's a battered woman. That's because she lies for gain. I don't want to be unnecessarily harsh, but let's face it, that's what this is about. She took the fifth so that she has that protection to not be cross-examined. But the court is going to allow us to bring in evidence that she lied for gain on repeated declarations for money and got that money and continued to get that money, and lied and cheated her way through life. That is what she does. That has nothing to do with being a battered woman. Now, the people say, well, they should bring this in, and because Mr. Auchincloss says she's really suffering from post-traumatic stress disorder, which is interesting, because they specifically asked to exclude Dr. Hochman's testimony, who indicates that she is basically an antisocial personality disordered person, who coaches her children to lie. Remember, Dr. Hochman was the one that said that, and that she lies for gain, and lied for gain in that case in the J.C. Penney's case itself. But he made a diagnosis after actually seeing her and evaluating her and testing her.
I'm going to object that misstates the evidence, and this should be a legal argument rather than a factual one.
Well.
Overruled.
If they bring in PTSD and say that's what this is all about, and she can get up and say whatever she wants, obviously it proves too much. It's not relevant to this case. It's not relevant to the facts of this case, despite the heroic effort to stretch it. But it would prove too much. Anybody who claims that they were assaulted by their husband could come into court, lie in the trial proceedings before the court, lie in countless other proceedings, and under oath, and then say, I get a pass. Now, there's nothing funny or nothing to be minimized about being the victim of any kind of violence, whether it's domestic violence or any other kind of violence. But it proves too much to say that therefore this witness, who Your Honor heard for 5 days, and we'll address this maybe in an 1118.1 motion at some point here. But without prejudging that, Your Honor heard this witness for 5 days. That is not the behavior of a shy, hopeless. What were the words? A hopeless person who can't stand up for herself. She was perfectly willing to take Mr. Mesereau on as aggressively as possible. She has taken other people on in her history in that very same way. When she wants something, she will get it. There is nothing shy about that woman that was on the tape that was trying to keep herself situated as close to Michael Jackson as possible, while denying that Jay Jackson even existed. There is nothing shy about this woman at any time. And she'll get up here and blatantly lie. If the court says, well, you can, if any court said, well, you can bring in an expert to say this person gets a pass and they can lie, what's the point of cross-examination? What's the point of coming into court and having the jury hear these things? Now, it simply proves too much. It's not relevant to the facts of this case. If they do intend to bring in something like that and claim that it shows PTSD, and therefore she's not able to tell the truth, what does that tell us? But if they're able to do that, then we should, of course, be able to bring in Dr. Hockman to say he knows exactly why she doesn't tell the truth.
Don't you think there's relevance, without conceding your position, though? I'm having trouble with you, just like I am with the district attorney. There's two areas we're talking about. One area, the claim is that she was the victim of abuse by David Arvizo. And as the district attorney pointed out in his argument, neither side seems to be. That's not an area of contest in this case. You know, when it occurred, and all that, may be, but not that it actually occurred. So then we have the actual impeachment by the defense of her testimony that Mr. Arvizo was abusive by you. The defense, bringing in the depositions of the J.C. Penney case where she denies that he's abusive. And I don't want to go into the evidence at length, but there was a considerable amount of evidence relating to her responses in the J.C. Penney case, and then the final, ultimate statement by her that if she, was at the point that he was finally arrested and removed from her presence, that she was able to go to her attorney and explain some of the untruths that she told. That's one area. Now, what's your argument, without drifting, please, as to the relevance of expert testimony explaining the spousal abuse accommodation syndrome in regard to that issue?
Or battered women's syndrome.
Yes.
So, if I'm understanding the court, taking the argument, and I understand the court's advancing for the purpose of discussion, taking the argument.
You're giving me a discussion, yes.
Taking the argument that, while the testimony might not be admissible with regard to Mr. Jackson and any other conduct associated with people at Neverland, the argument may be relevant to explain what happened with David Arvizo and why she may have lied in the J.C. Penney's lawsuit.
Yes.
Okay, first of all, under 352, let's start there. The court has to make the cut at some point on evidence that is going to come in to explain what is an issue in the case, but it is not the core issue in the case. And the court has made that determination with regard to Dr. Hockman, for instance, that we cannot bring in what we considered to be probative evidence. The court did not say it was not probative. The court said that you were going to exclude it, I take it, in part, on the grounds that it would be. I believe the court said on the grounds that we're not going to have a complete trial within a trial on all aspects of it. So there does have to be a cut of some sort. And it seems to me that's a place where we can start with the discussion. Can they, in a trial where Mr. Jackson is on trial for his liberty over what these people allegedly did, we're going to have an expert come in, whose testimony should really be limited to this very small area. Now, I understand if the court were to do that, Mr. Auchincloss would not be allowed, nor would anybody on that side be allowed to argue that this testimony explains away her perjury in this case or her perjury in other respects. But Your Honor would propose that somehow the jury be limited to that. And so under 352, besides the undue consumption of time, you have the potential for prejudice to this defendant, to whom this witness would not apply at all, but the jury would not be capable of making that very surgical line, if you make a line surgically, but make that line very specifically. So it would cause prejudice, and it would cause undue confusion to the jury, besides the undue consumption of time. Now, I want to address the relevance issue even more specifically, but I started with 352, because I think that really answers the question. But going more specifically beneath that, to whether or not it's probative at all on this, Your Honor said we don't dispute that she was abused by her husband. There's already been reference to the fact that there was a photograph taken of her where she was appearing to assault her husband with a knife. And she said it was all a game, but I will represent to the court that we have a number of witnesses who say that she was the violent one in the marriage, and was, in fact, striking not only her husband but other family members, and she's.
I'm going to object that this is all irrelevant as to what Janet Arvizo is and what she may have done.
Overruled. Go ahead.
And we have a number of witnesses who we could call for that. Whether we will call them, I'm representing they've been interviewed and that's what they say. Whether we will call them is a question of trial strategy and tactics, depending on where this all goes, of course. And there's evidence that, well, suffice it to say, without going into the detail, there's evidence from third-party witnesses and family members to that effect. Given that, if the court allows her to now shore up her credibility as to why, sort of a strange phrase, shore up her credibility as to why she perjured herself.
That's a phrase you've been choosing. I mean,
What the prosecution would be saying. Your Honor argued this for them, I suppose, because we're talking about this narrow issue. What the prosecution would be saying on this part of it, I suppose, is, look, of course she lied in J.C. Penney's because her husband's abused her and she's afraid. So then when she testified, she not only testified that her husband never beat her and she loved her husband, and they had a hideaway love nest, and there was all these other things that went along with that deposition, but she also felt compelled to testify that she was sexually molested and all the other things that came out in that deposition that were just inherently preposterous. And they would argue, well, she's a battered woman, so she tends to lie about everything if she lies about anything.
the expert on the battered women syndrome. Doesn't the expert in that situation just explain why a person who's been the subject of abuse might not report it? Might not report it accurately? Might at one time say one thing about it and other times about another? That explanation doesn't extend to everything a person says thereafter to anybody, does it?
Well, it shouldn't, but I heard Mr. Auchincloss just argue that it does. However, focusing on the court's argument, the question is what would the expert bring to this? The expert is not going to be able to substantiate the argument that Mr. Auchincloss made, and that's my point. The expert's not going to be able to say that she committed perjury just in general because she's hopeless. The expert can simply say there are syndromes where a woman, or a man, or anybody that's subject to a battered person syndrome, usually a woman, hence the name, but where a person is subject to this syndrome, they are beaten down, they're dependent on the person, they feel hopeless. And the theory goes, therefore they don't necessarily avail themselves of conventional means to resolve the problem. They tend to go back to the person. Things that Mr. Auchincloss said are common. I won't adopt them all, but those that I'm repeating are common denominators in the expert testimony. And that will explain the traditional case where, in fact, a woman doesn't go report it, and when asked, after being beaten, says, no, I wasn't beaten. It just doesn't explain the facts in this case. When I say, this case, I mean the J.C. Penney's case. It certainly doesn't explain anything in this case. But in the J.C. Penney's case, it just doesn't explain the facts that are in that case, where she will go in for gain and make up a big story about all sorts of things for gain. And then remember, Your Honor, it's not that she's afraid to report her husband. She reports her husband 5 days after they get a settlement by mediation, while they are still deciding how the money's going to be split between them. And during the months that ensue, they can't decide, the insurance company files an interpleader. I don't know if they actually filed, but stated in correspondence they're going to file an interpleader because they don't want to have anything to do with it. She reports him then for sexual abuse. And he finally says, I give up. I'll just take $5,000 for my divorce lawyer and you can have the rest. And that's not a battered woman.
You're really not addressing the issue. But
I'm trying.
let me ask you the other question.
I'm sorry.
The area I cut you off on. I just wanted to hear the argument related to my hypothetical, so I cut you off from arguing why it shouldn't apply. If the expert actually purported to be able to apply it to a situation outside of the marriage or the relationship, such as the Michael Jackson connection that she has. I'll let you argue that a little bit, because I wouldn't let you argue it.
All right, and not wanting to decline that invitation, could I make just one closing remark on the other issue?
If it relates to my question, yes.
And I want to tie it to the question. I think that is the question. Is Your Honor says if it was limited to that issue. I suppose the question is how do you limit it to that issue? And that's why I come back to the 352, which is if you let in a battered woman expert on that, then we have all this other evidence as to whether or not she was actually battered, and whether or not she was behaving in accordance with a battered women's syndrome, which would open that whole area substantially more than the court, I think, intends to have it opened at this point. Having said that, that was the point of going on about the additional facts with regard to that point. Having said that, the greater argument, as it pertains to Mr. Jackson, who, after all, is the person we're representing, we're not taking David Arvizo's side or not. You know, that's something that either did or didn't happen. The question is whether or not Janet Arvizo is telling the truth in this case when she's accusing Michael Jackson and other people at Neverland and elsewhere of doing things to her. And this syndrome, as it's typically described in the testimony, would have no application to this picture, despite Mr. Auchincloss's argument that basically explains perjury in general. Not only that, we still do not have an specific offer of proof or a report of anything from a battered women's syndrome expert. And as far as I know, they haven't elected which one of the number that they listed on their list they were going to actually call. So we don't know what they're going to say. We have to assume they're going to say no more and probably no less than they generally will say in domestic violence cases or cases in which the parties, whichever one is the victim of the ultimate offense, where the parties are husband and wife or boyfriend and girlfriend, and they have that kind of a relationship. So if they give that kind of testimony will not apply to this. That means that they are expecting to call somebody who is either going to say that, and therefore there's no relevance, or they're going to call somebody who's going to expand on the theory beyond any measure upon which it's been approved to explain that somehow this can give an account of what happened here for 5 days.
Have you ever seen a case where it's been applied, this testimony, to anything other than the people involved in the relationship?
I have never seen such a case. I have never seen such a case reported. And let me just ask very quickly. Did you see a report of this?
No.
And Mr. Dunkel, who is religiously researching some of these things, particularly the last-minute motions, has tried to read every case there is on all of these things.
If the record could reflect, Mr. Dunkel shrugged his shoulders.
Clearly he said, no. Right? I heard him absolutely say, no.
I'm a battered defense attorney.
The way he was shrugging his shoulders was in fright. It was, don't ask me. Laughter.
That's correct.
As a battered defense attorney, I may not be able to hear him clearly. I guess that's
okay.
The point is, I just don't see how it can apply. If the court has any other questions, I'll answer them. Otherwise, I'll submit it, Your Honor.
2 comments.
I'll let you make your 2 comments, but let me ask you the same question. Do you have any case where this has been allowed or used other than between the 2 parties and the typical domestic violence situation?
I don't have a reported case.
Do you have any unreported case? Oh, you're not supposed to cite those, are you?
Rule of Court 977, but the delay answered the question.
You should have let him make his answer and then move to strike.
But the bottom line, one of my 2 important points is, number 1, this is apples and oranges to Dr. Hochman, who would testify specifically about Janet Arvizo. This is not going to be testimony about Janet Arvizo.
No, I understand that.
This is just general testimony. Mr. Hochman would testify about specifically Janet Arvizo and it's inadmissible for that purpose.
You're getting.
Putting that aside, I want to make that point, because it's not prejudicial to the defendant. It's not about the defendant. It's merely some information that the jury can use or not use. It's up to them. If they think it applies to this case, no problem. If they don't think it applies, they're the arbiters. So in terms of prejudice, really all it is informing the jury of the truth about a certain syndrome. Secondly, as far as this thing about perjury, I've never said that this gives her a pass to commit perjury. And battered women's syndrome does not provide any exculpation of an individual who lies under oath except for the individual who lies about their mate. That is the one area, when they say, he didn't beat me. When they say, he didn't do anything. When they say, he's a great guy. Oh, he's a good person. He's an honest person. When they say those things, that's where they do get a pass, and that's the only area. And that's what this witness would testify to. And that's why it's so important and so probative in this case. Thank you.
This is an area that has caused me a great deal of concern. Probably why I didn't rule on it initially. I wanted to hear all of the evidence before making the ruling. And I think this type of evidence is valuable in domestic violence cases for jurors to help understand the dynamics of a particular relationship involving violence, but I'm not going to allow it in this case. It may or may not explain her, or a person's conduct in a similar case, such as the J.C. Penney case, which was not a domestic violence case between her and her husband either, as this one is. And I think it would be a mistake for me to allow that type of evidence on what is a peripheral issue in this case, i.e., whether or not she told the truth in the Michael Jackson, in the J.C. Penney depositions. The court will also find, under 352, that in this case the prejudicial effect far outweighs the probative value of the information, in that the jury might well confuse the purpose of the testimony, which would be, the only way I could see it at any time would be to explain the relationship of the abused and abusing couple. And I also think that, under 352, to allow the evidence would force the defense to approach the abuse in a different area, a different way, which would cause an undue use of time and prolong the trial unduly. So for all those reasons, the court will deny the use of the expert on the spousal abuse syndrome. The next issue we'll take up is the plaintiff's supplemental motion for admission of additional evidence pursuant to Evidence Code Section 1108.
Judge, I'll be brief. I just want to correct a couple of misconceptions in the response by the defense to this motion. Mr. Kassem was on the original witness list and has been since the beginning of this trial. Secondly, the discovery with regard to Mr. Kassem's statement was provided, along with all the other materials, back in October of 2004 of the statements that he made to police in 1994, in May, during the course of the first investigation involving Mr. Jackson. These have been known to the defense since that period of time. With regard to the motion itself, I will indicate to the court that he was not on the list of the 1108, because in my view, with regard to the observations that he made, as I've indicated in the brief, they were corroborative of the testimony of Mr. Chacon and did not involve the actual seeing of any misconduct on the part of any individual. And frankly, it didn't dawn on me that he couldn't just come in and testify to those events. However, when the court asked me to do it and put it in writing and defer his testimony, I was more than glad to do so. But this is not something that we're trying to bootstrap into something we didn't plan to do a long time ago. He's been on the witness list, items have been discovered, and so we filed a supplemental motion. And I believe that the evidence is probative and is admissible under the code section and certainly sets a stage and corroborates the testimony of Mr. Chacon in terms of the fact of the defendant being with the children that were mentioned by Mr. Chacon, and the events as mentioned by Mr. Chacon, and then the corroboration of the incidents by finding the swimming trunks in the restroom when he went to turn the lights off immediately after the defendant went from that position to the house. I'll answer any other questions that the court has, but I wanted to explain those differences between our position and the defense's position on the factual issues in terms of what was and was not provided.
Okay, counsel?
Yes. I don't know that there is a dispute, nor did we intend to say there was a dispute about what Mr. Sneddon said. All of the people that they could find in the Abdul, Chacon, McManus, Doms and Bagnall versus Jackson case, the civil case, all of those plaintiffs were listed as potential witnesses in this case on the December 6th witness list, as I recall. If it wasn't that one, it was the one shortly thereafter. That was not our complaint. Our complaint was that Abdul was not listed in the 1108, specific 1108 motion where the government spelled out what they intended to prove. It has been and continues to be our contention that the government is required to turn over witness statements of witnesses who talk to the government, whether it's police officers or district attorneys. And our concern is that we had reports from 1994. We've had testimony, of course, from this Mr. Abdul in 1996 or .7, and that was involving the case I was involved in representing Mr. Jackson, but we don't have any current reports. And it's just hard to imagine that any of these witnesses, and I'm taking just a moment, because this applies to other witnesses that will come up, that any of these witnesses from times gone by would just be called to the stand cold, without even so much as a re-interview. So that was our concern, so that was what we were trying to express. And without anything new, and without anything by way of an offer in the original 1108, all we have now is the new offer, which is not based on declarations, as so many of these motions are. They're just things that are said in the motions, and the government wants to call Mr. Abdul for that. This goes far afield. The court was limiting the testimony under 1108, recognizing, I believe, that 1108 evidence can be very distracting to the jury for the same 352 reasons that we've discussed before, and the court made an effort to limit it, my belief was, to people who saw some actual acts or purported to see some actual acts that would amount to actual evidence as opposed to circumstance and innuendo. And not to go on about all the details of Mr. Abdul's testimony and whether or not it's been refuted by his own words, which I can indicate to the court it has been, but aside from that, you're talking about a tangential witness to shore up another witness who has testified here, and we're turning the 1108 into more than it should be turned into. This still remains a balancing act, and the court has discharged that duty to balance by attempting to limit the 1108 testimony so the jury could hear what might be important to hear for the purposes set forth in 1108 and not to allow 1108 evidence to overtake the significance of the actual evidence in this case of guilt or innocence. And so I think that expanding it any further would be a mistake, and I think it would be harmful, be prejudicial, for all the reasons under 352, consumption of time, confusion to the jury, and prejudice to the defendant. Thank you.
Your Honor, I just want to make one comment and all, with regard to Mr. Sanger's position. I think that there's 3 incidents, and I tried to be specific about the incidents involved in the offer of proof. And clearly, my take on it, and has been from the beginning, that the first 2 incidents that really frankly involve relevancy issues more than anything else, and that they're like having multiple people see the same events and you're allowed to call people in to testify to certain portions of what they saw during the course of those events. Clearly, I think the third incident is one that is more akin to the 1108 and 1101 kind of evidence that's been before the court. But clearly, I think the first 2 incidents are ones that are more, in the sense, relevant because they corroborate Mr. Chacon as to significant events that he's testified to in this case. And there's been an attempt by the defense to claim that this evidence was fabricated based upon his involvement in later suing Mr. Jackson. And I think in fairness to Mr. Chacon, when there's a witness out there who can testify that he was also there that night and he also saw the same things that Mr. Chacon saw, in terms of the setting for the event and placing Mr. Jackson with the child at the time that Mr. Chacon says, that's highly relevant evidence that this jury should be presented with. So I think there's a difference in the basis for which the first 2 incidents would be admissible as opposed to the third. And I'll submit it.
You know, I want to take a couple of minutes to read the briefs again on this. I'll take a 5-minute recess.